A very warm welcome from Nivaran, group of mediators at Supreme Court of India, to the students and peacemakers, that is mediators, who have joined us today from all over the globe for this third international virtual mediation summer school 2020, the second day. I am Mridul Aggarwal, an advocate and a mediator at the Supreme Court of India. It's my privilege to be the host of today's session. We have Mr. Jamshed Pey, an advocate and a mediator at the Supreme Court of India, as co-host. Mr. Rakesh Khanna, who has been the president of Supreme Court Bar Association, Mr. Jitendra Sharma, Mr. Rajiv Datta, are senior advocates and leaders of the bar. It is through their unstinted support, Nivaran has been successfully promoting mediation for the past 2 years. Rahul Kumar is a young lawyer who has just joined the profession. Being a tech-savvy, Rahul has been with us throughout and forms our backbone in hosting all the webinars, etc. Mr. Santhanan, do not need any introduction, is working day and night relentlessly to bring our Nivaran at this height. This is the second day of the school. Yesterday, being the first day, we learned about the historical perspective of the dispute resolution. Today, we have our honored guest speaker, Mr. Ajay Mehta, a renowned mediator from India. It's my pleasure to welcome you, sir, and introduce you, Mr. Mehta, on this platform of Nivaran. Mr. Ajay Mehta will be enlightening us on ethics and ethical issues in mediation, confidentiality, neutrality, and self-determination. Ethics, what is ethics? We remember having moral science subject in our school teaching us how to behave, which regulate our conduct. It wasn't a compulsory subject where its marks were not included in the main score. I request all the authorities from this platform to make it necessary subject. It's very important. Remember the story of an ant climbing again and again, silently putting hard effort. Next time, and it climbed. The same way, here mediator has to silently put efforts to resolve the conflict, the basis of dispute. Mediator has to communicate in the way the parties comprehend and start communicating amongst themselves. Ethics is derived from Latin word ethos, meaning custom, which means habitual conduct, mode of conduct. That is, some written or unwritten rules which we have to follow from ages, like we have customs which are not written anywhere, but we follow. So ethics is written or unwritten rules and regulations which a professional must follow. In mediation, we understand ethics as not to pressurize the participants to reach to a conclusion. The rights of the parties to reach a voluntary agreement is the central to the mediation process. A mediator has to maintain his dignity and integrity. A mediator should avoid potential biases on account of many factors. Quite possible the mediator himself have undergone the same issue in his life. I would request Mr. Speaker to throw some light on this as to how to keep yourself away mentally and keep unbiased attitude in such circumstances. A conducive behavior has to be adopted. I remember during the training, our trainer, Madam Sarla, taught us that when the parties enter the mediation room, the mediator should stand up and greet everyone with a smile so that parties feel comfortable, making them understand that everyone is special and you are ready to give them a patient hearing. Thereby, a trust is developed. Many acts in the mediation has been incorporated, like Hindu Marriage Act, etc. We learned it yesterday. In 2007, Ministry of Labor, Industrial Relations, Tourism and Environment promulgated Code of Ethics for Mediator way back in 2007, setting the minimum standards to guide mediators in performing their duties and functions as required under Section 199 of the Employment Relations Promulgation 2007. It provides the mediators the framework for ethical practice considered essential in his or her conduct of mediation, which are detailed under Section 199 of the promulgation. Our esteemed guest will be talking to us about the ethics of mediation in the latest mediation bill pending with the Parliament. Mediation is by its nature a fluid and flexible process. Mediators are not expected to adhere to one process or approach and are encouraged to rely on their creativity and experiences to tailor each mediation as much as appropriate to meet the needs of the parties. A mediator should withdraw under certain circumstances, like maybe mediator knows one of the parties, then he should withdraw or bring it to the knowledge of the other party to escape bias. Mediator should not guarantee results. In Nivaran, we are essentially performing court-annexed mediation, but in the mediation in general, who are imparting private mediations should not guarantee result pertaining to one type of industry over another. Mediator's role is of neutral intermediary, should avoid giving legal advices. In matrimonial matters, many a times parties are worried what the neighbor will say about my relations, are saying, what our people are saying. We must tell them. One great scholar once said, at the age of 20, we worry what others think of us. At the age of 40, we don't care what they think of us. At the age of 60, we discover they haven't been thinking of us at all. So we should encourage them to focus on their own relations instead of thinking about others. With these words, I invite Mr. Ajay Mehta, our guest speaker for the day. Sir, please enlighten us with your vast experience in the field of mediation. Mr. Ajay Mehta is an eminent mediation trainer and an expert in negotiation and communication skills. He is an alumnus of Law Faculty, Delhi, 1977 batch. Mr. Mehta has been in the legal profession for the past 45 years. He was accredited as a mediation trainer by the Supreme Court of India in the year 2008. And he was further appointed as a mediation trainer by the Mediation Monitoring Committee of the Honorable Bombay High Court in July 2000. As a mediation trainer, he has traveled all over the country, imparted 40-hour mediation trainings to around 1,500 judges and social workers, advocates, bureaucrats, and law students, and has also conducted awareness programs for about 5,000 people all over the country. He has also conducted mediation workshops in associations with various law colleges around India. He is also the director of Mediation and Research Center, Maharashtra, National Law University, Mumbai. So I welcome Mr. Ajay Mehta. Over to you, sir. Thank you.
Thank you so much. Thank you, Mridul, and my compliments to Nivaran for the great job and for getting me here. And please accept my compliments, Bridget. You are there. Sivanathan, Rajiv, I have already spoken to you. So I move on to my presentation. The only thing prior to that, which I'd like to mention, that I have not made any modifications in the presentation. So it does have some words in Hindi, a few lines, few sentences. So please excuse me for that. Since I find that to be the essence of my presentation, so I have not deleted those portions. So over to my presentation.
Mr. Mehta, yes, now it's okay.
Well, like me, even others may have noticed this. This I have seen on Indigo flights, written outside the entry of the pilot. I really feel very strongly that this goes so well that the mediator must disconnect himself before stepping in his chair as a mediator. All worries or concerns, all those things which are haunting him, and he is wanted in the courts. So to begin with, we are talking about ethics. So following the morphology, the stages of mediation, and whatever we have understood by way of trainings, 40 hours trainings that we have all got, and the skills, tools and techniques. So we must follow those stages, tools and techniques. It's very important. This one just an indication to this, the way we have margins in the books or any printed pamphlet. So those margins are indicative of neutrality, integrity. So we have to keep certain things away and appreciate that part. Mridul, just to confirm with you, is this slide clear?
Yes, sir. It's completely clear, sir. We can
Right.
see.
Okay, thank you. Well, our joint sessions, single sessions, sub caucus, all that is very encouraging for the parties to open up, and we use our communication skills. But then they have this assurance from us that the privacy and the secrecy that must be assured and must be followed. Very important. But then it's not just on the paper. from the facial expressions and the behavior, body language of the mediator, this must reflect, and this assurance may not come just by words. It should reflect from his personality, that he is the person who can keep secrets, and the parties can be comfortable and sure about it. Once the parties are sure about it and they open up, then of course the session moves ahead. And the parties, once the parties start opening up and they are sure about the mediator and his assurances, verbal and non-verbal both, then the mediation moves on. See, right from the time the referrals are made in a court annexed mediation, then of course, those who are successful as a mediator, gradually they start believing in numbers. And why I say Club 99? Because suppose if the mediator has been successful and there has been successful mediation in 40 matters or 45 matters, then he looks up to 50, the number of 50. And if, especially I remember that initially it used to be that somebody who has handled successful mediation in 50 matters or 100 matters may be considered to be a trainer. So therefore, those become the targets. But if that becomes the target for a mediator, then it is highly unethical, because with the speed that is desired by the mediator to achieve personal goals, then he may not be bothered about right of self-determination, which can be very harmful, counterproductive. So a mediator not to be a member of Club 99, the first thing. So should be very clear that the matter in your hand right now, that's important, not your goals. So right now, these are the ethics for the referral judges, which we follow to ensure presence of the parties at the time of referral. That's very important. But more important is that if the referral judge interacts with the parties, because I have seen that how it helps during the mediation, because at the time of referral, interaction on the part of the honorable judge with the parties, that encourages them, and that leads to a successful mediation. The encouraging words, the faith in the mediation system, passing appropriate referral order. Then this is more important, that when the matter is being referred for mediation, parties must feel that the time is not being wasted. An effort is being made to refer the case for mediation, which is a good opportunity for the parties to sit across and try and settle the matter. But if a date is already given by the referral judge for the next appearance and what is it fixed for, then they will be assured that it is not an adjournment. So that adjournment culture will not hit them mentally and psychologically. They will rather feel that is something between today and the next date of hearing, that I have to visit the mediation center and I have to be with the mediator, and that's it. And obviously, if someone is ex parte, then the case will not be referred to mediation. Now, this becomes very important, that the referral judge in no way should interact with the mediator. whether it be an advocate mediator or a judicial officer who is the mediator, should never interact or try to know as to what happened in the matter which I referred for mediation. That will be highly unethical. Because the mind of the referral judge should not be prejudiced. It's good to be honest and humble in personal lives, but when we come to mediation, it's very, very important for a mediator to remain humble, courteous. He is also to ensure that the mediation which is being conducted should be harmless. The parties must take it this way, that it may do something good to them if the matter is settled, but it will not harm them in any way. I'll have to talk about right of self-determination of the parties. I would like to very candidly admit one thing, that if we expect, for example, advocates to undergo 40 hours training in mediation and inculcate ethics, the culture, well, it is difficult. It takes time. It needs a lot of hard work, a lot of practice. So any hurry on the part of the advocate mediator or the judge mediator for that reason, just because they have their mind in the courts elsewhere on other commitments, that may upset the entire concept of right of self-determination. In a hurry to have the matter settled, and when I say matter settled, I have come across hundreds of mediators who claim, especially on social forums and during conferences and otherwise, that I have settled 1,000, 5,000, 10,000 matters. My question is, if you have settled 1,000, 5,000, 10,000 matters, then what happened to the parties? You didn't settle. You were a facilitator. If you really claim that you settled, that means you took away somebody's right of self-determination. So for me, it's very important making such big claims, having settled the matters. No, it is the parties who settle the matter. You are a facilitator. The parties have not been on talking terms. So you facilitated, you infused communication between them. They started talking. When I'm speaking about this, I have also seen in my years of mediation and as a mediation trainer that the mediators very often they pick up this style that just a moment, I'll listen to both of you. Now, this is something unethical, I will say. I will listen to both of you. No, the job of the mediator is to facilitate communication. And like a honorable judge, he cannot say, I will listen to both. No. He has to see that the parties, they are addressing to each other. They have started talking to each other with dignity and show discipline. So saying that I will listen to both of you, that's not logically correct. So self-determination, very important. and as important as informed consent. And informed consent can come only when you allow parties right of self-determination. They have to decide, not the mediator. And when I talk about this topic, I normally use this slide. On this slide, you will see the word, my second child. I always like giving this illustration. As my second child, my daughter was about to join us. My wife was pregnant. And once she was admitted to the hospital, I was around and I was told that you are going to have a cesarean baby. Once my wife was taken inside the operation theater, the doctor in between called me. And I was surprised that at that time she should have called me. She should have focused on the patient, and I was awaiting the good news. But instead of that, she asked me that right now, when your wife is on the operation theater on the table, do you want me to control your family? Meaning thereby you already have one child, there's going to be the second child. So you logically, you should not want more children. So should I ensure that that part is also taken care of? I was shocked. And I am talking about right of self-determination. I folded my hands and conveyed to the doctor that your patient who is right now in your custody, she has to decide whether she wants more children in her life or not. So I cannot be anybody to give my consent to this. So that is about the story of my second child. And I very proudly share this on this topic, that after my second child was born and my wife gained consciousness, well, she was so excited about this that she still has the right to have more children. We stopped over there. We have 2 children, but the thing is that her right of self-determination was not taken away. So this is, I'm a happy man sharing this incident. The children have grown up, but this still is very dear to me, this incident, and that's why I do share this. So talking about partiality, we are the caretakers of the interests of the parties. And we look beyond the parties as our ethical duties. So to remain and continue to remain impartial. Now, this is very important because one obligatory part is to bring the parties to the comfort zone. But with the advancement of techniques and digital world, the mediators, when I became a mediator in 2006, the digital things were not so advanced and whatever, but subsequently we were finding that parties were trying to sometimes record. They had recording devices as simple as a pen or otherwise, which were not visible or understandable by the mediator, beyond understanding, beyond our contemplation. But really it became necessary to, during trainings also, to tell people taking trainings and becoming mediators that you have to take these precautions, because we physically found people carrying devices and recording the proceedings which are supposed to be confidential. And to ensure, now civility is very important, because parties sometimes have plan B. They come to mediation sometimes to know the intentions of the other party, take the matter back to the court and use it in cross-examination, evidence or whatever. So, and even otherwise, dignity and courtesy. So to safeguard people against incivility, coercion, collusion. And we have to actually understand our own things. In one of the matters, I was the mediator. I realized that the wife, who was adamant in the first round of mediation, she wanted to retain the custody of the children. 498A, the cruelty issue and everything that was over there, there was an FIR, but the matter was deferred. And on the other date of hearing, on the other date, sorry, not hearing, on the other date in mediation, suddenly the wife says that I'm prepared to give the custody of my sons. And in fact, they are already with my husband. As a mediator, I was troubled. This kind of the attitude of the wife on the previous date, and now I decided to take sub caucus, and somewhere with efforts, I got to know that actually the two children, the sons, they were kidnapped from this after the school hours from the school by the father. So that is what the husband used the mediation for finding an opportunity between the two dates of hearing of the court. He took away the children from outside the school where they were waiting for the bus. So coercion, collusion, or any plan B, well, it has to be understood and to be taken care of. Similarly, one more example, that there was a suit for partition between the brothers. The parents were no more and the property was inherited. They filed a suit for partition in the court and got it referred to mediation on the very first date of hearing. When the matter was going on, I decided, and they gradually became prepared that all right, we are ready for the settlement. Within no time, they were ready for settlement. But instead of relying much on the joint session, I still requested that I think it is obligatory on my part to take a single session with all the three brothers. I was having some doubts. So instead of putting my questions in the joint session, I preferred a single session, sub caucus, with all three brothers. And somehow one of them spilled the beans that they also have a sister. There was no mention about having a sister in the petition anywhere. When I asked them, I went in for a joint session, asked them, then they said the daughters have no rights. It's only between us brothers. So therefore, plan B may be lurking and shadowing the mediation sessions. The mediator has to be very careful. There can be misrepresentation before the court, misrepresentation before the mediator, and the settlement going back to the court. That means somebody has been deprived. Somebody's rights have been taken away. So a mediator has to be, beware of any misrepresentation. That's very important. If the court has referred the matter, that means the court has placed responsibility on the mediator to take care of things. talking about integrity and neutrality, I think the first thing that comes to my mind is that giving trainings in mediation and acting as a mediator, or expecting my colleague mediators to follow integrity and neutrality. The question is, was it involved in their upbringing? Was it involved, this quotient, was it involved in their upbringing, their education, their normal life? It's very important. And here, when I've been given the liberty of taking this session, without saying much on this, but do we take precautions of selecting mediators who are rich with these vital things? Do we look at the competence of mediators? I'll be very candid and honest. I've come across mediators. I'm talking about having traveled all over India. It really sounds good that I've traveled and I've given mediation trainings. But the thing is, I've come across mediators who have FIRs against them, serious ones. So talking about integrity, neutrality, yes, that must be complied. The mediator must be very serious about it. There are very important things in kind, but the selection process should also be on these lines. Very important. I can just exemplify it this way, that being at the airport, sometimes we need to leave our handbags at the airport where we are waiting for the flight. Then sometimes we look right and left here and there, and then find a shortlist on a person. Can you just take care of my bag? I'm just coming in 2 minutes. Now we are very careful in trying to understand the people sitting around me, whom I can entrust, that I'm leaving the bags for 2-3 minutes. Imagine and compare that conveying the confidential aspects of my life in a matrimonial matter or a family dispute or a corporate dispute, most confidential aspects conveyed to a mediator, and that mediator must be qualified enough and competent enough to handle those confidential things. And inculcating the belief system in the litigants, in the parties, to believe that yes, once I have given away or handed over those delicate confidential aspects of my matter, they are going to be safe with the mediator. So I do talk during trainings that what you are dressed, how you are dressed up, your simplicity, trustworthiness that looks like in you. So those things are very important. Somebody ensuring and entrusting and trusting about the privacy and confidentiality to be understood. Within this, I would like to mention about one of the mediation sessions which I conducted. This was, I think, either 2007 or end of 2006. And I was surprised by the number of my guests, parties. They were almost 70 to 80 persons, 70, 80 people stepping into my room, mediation room. And well, neither the males nor females. So that was the gender of my guests. And I, for the first time, got to know this was basically an injunction suit. They have areas divided in the localities. They go on marriages, birthdays, and in posh areas. So their source of income, I was surprised to know, and what potentials are there. So they have Guru Shishya Parampara, the teacher and the disciple. One disciple changed sides, left one guru and joined other one. And that was a total collapse of one team. That was a suit about on injunction. This was the case referred to mediation. And you can understand that for me, the most important thing was to understand the matter and to ensure peace. Peace not only in my room, but the entire mediation center, which had 10 to 12 mediators working around that time, and almost 200 people waiting in the area. So first of all, to arrange chairs for all of them and whatever. I wish to share this with you, that they came to the mediation center thrice and the matter was before me. There was a pin drop silence. Nobody raised the voice. And so this is what privacy and confidentiality and the procedure and the ethics. So you could inculcate in them. Sometimes when they visit your house, you are really scared that what kind of a noise, and there can be consequences if they are not controlled. So the thing is that this is in the domain of the mediator, how you carry yourself and how you believe in the system and how you can encourage the parties that they will not be neglected and believed. So all a matter of the confidentiality and that of the process. Then it is important for the mediator to follow the statutes. They must be aware of the rules. Where I have my own doubts, sometimes the rules are not clear to the mediators. It's very important that you know your rules. Also that you know the model rules framed by the Supreme Court initially. So abiding by the rules. And obviously the judges not to act as mediators in cases pending in their own courts. And it is very important for the mediator, when we are talking about ethics, must know the AFCON's judgment clearly and absolutely, whether it be Section 89 or the AFCON's judgment. Because prior to the AFCON's judgment, it was mandatory on the part of a mediation trainer to explain what type of cases can be referred to mediation, what stage, what cannot, so all that. But now AFCON's takes care of everything. So the basic understanding and a vast understanding, I will say, of the judgment is very important and will be a part of ethics. It's very important for the mediator never to pursue or think about personal interests and gains in the mediation session. I would like to give one instance here. So that I can explain myself that how important it is for the mediator to follow integrity, neutrality, honesty. Well, it was a matrimonial matter. Husband, wife finally resolved that they will go in for mutual consent and the assets will be divided. They finalized about the custody. All issues were taken care of. Now the question was that the husband will look around for a small apartment for the wife, and they sought time in mediation from the mediator that it will take some time to explore finding a flat for the wife, for which the husband was supposed to pay. Now, at this juncture, Well, I think that it must be a matter of guts that I'm going to convey what I'm going to do. That the mediator had some wonderful idea. He was having a small flat which he was unable to sell for almost past 15 years. And I'm shocked that in a court annexed mediation system, the mediator offered his flat that if you wish, you may buy this one. We talk about ethics, we talk about honesty, integrity, neutrality, the goodness of the system. But if the mediator sits for personal benefits, then I think, well, talking about ethics, that so this is a very painful aspect. But I wanted to, and I did talk about this for the sake that it is not just ornamental to present this PPT. It should mean a lot. It should convey we need course correction. So the words as go, as you see, not to be a profiteer. I think I got provoked because the integrity, neutrality, honesty, the person of character, moral character, this cannot be in words. It should be followed. I will again repeat my intentions that even in the selection process of a mediator, that is the stage where the system must look into it. I proceed further. No communication with the referral judge. The mediator should never contact the referral judge. Stay away. I have used the word Sapinda relationship because I do understand what I want to say. So I'm making this statement in a very responsible way. In fact, when I'm doing this, then I must emphatically say so, that mediation got evolved. It's a good thing. We have come a long way. But the meeting of through mediation is one of the platforms where the advocates and the judges, they come in contact. They get to know each other. This is something where we must ensure that this meeting is very constructive and is not misused by anybody. I cannot elaborate this further, but this is very important. This is a very delicate issue. They should not get the freedom of knowing each other too much. Limited to mediation. It's my personal knowledge that whether the mediation has been successful or the matter is returned, but the mediators, they share their cards with visiting cards with the parties. One more suggestion here, that we take notes during mediation. Well, I always inspire the trainees to write with a pencil, not a pen, for a psychological impression to be given to the conveyed to the parties that these are temporary notes which the mediator is taking, and that should be done after seeking permission of the parties. That I'll be, as a mediator, I'll be taking some notes, and using the pencil that conveys that these are disposable. It's not that he is going to inform anything to the court, whatever has been stated. So dispose of your notes in the presence of the parties at the appropriate stage. finally, when you come to settlement, if it is arrived at settlement, mutual settlement, then there are filters that is it benefiting both the parties? Is it as per the desired by them? Is it in the same language which is understandable by them? Have their advocates gone through the settlement? Is there anything mismatching? Which cannot be. This picture actually I very consciously I put it there. So it should not be a mismatch. So that is something to be done very carefully. So I'm simultaneously trying to look at the watch, and I should not be exceeding the time limit. Everybody's time is precious. And of course, I feel honored that being here on this forum, and time is the essence. So when I say thanks, thank you very much.
Thank you very much, sir. So we'll be having question and answer session now. There is a question from Gurmeher Van Singh, advocate.
Yeah.
Would it be ethical to make a party settle or get his dispute mediated while the party is completely oblivious to the fact that legally it can get much more?
Yeah. Just repeat the last one.
Yes, he just want to know that as a mediator, he is sitting in front. They are getting compromising. They are doing their mediation, and they are settled with the view with some little amount. But the mediator knows that the other party can get much more. So in that situation, what the mediator should do?
If it occurs to the mediator must make some last-ditch efforts, taking single sessions once again.
Okay.
Thank you.
Okay.
Mridul, I just want to confirm you that is it okay? I'm audible and clear?
Yes, you are audible, sir.
Okay.
Very much,
Okay.
very loud voice.
Sir, you yourself are not visible except your slides.
Okay, so I will take care of that. Thank you.
Now it's good.
Thank you.
Mr. Mehta, I have got a question. Just at the closing of your lecture, you said that the mediator has to see whether both the parties are equally benefited, or the settlement is both the parties are.
Jamshed, not equally. No.
Okay, fairly, I believe.
Fairly and willingness of both the parties.
Yes.
To carry forward that settlement.
I have a personal experience of this type, where the husband and the wife were on loggerheads with each other. Husband was completely unreasonable, and wife's condition was that she asked me, "Sir, kindly make a settlement. Wherever he'll say, I'll sign."
Yeah.
On whatever things he say. Before me, there were two more mediators. Somebody is speaking on the mic. Please mute your mics, please. So before me, there were two other mediators, and who had left the mediation in between because of his behavior.
Yeah.
So I used anger as a tool of negotiation.
Okay.
And somehow I could cowed him down to some of the terms. But even then, some unreasonable terms went into the settlement. They are innocuous in the, I believe, legally they can't be enforced. But can you just guide us under such circumstances when the one party is completely out of league and another is ready to submit to everything?
It's a fit case to return the matter.
Well, the difficulty was that wife started crying in the mediation room itself, and she said, well, I don't want to continue with this person in any case. Please close it down here only, or else I'll commit suicide. So,
Jamshed, I had similar experiences.
yes.
First of all, thank you very much for sharing this, because these situations, maybe once in a while, but we do come across.
Yes, yes.
And I have seen that, that having returned the matter of this nature, these matters do come back again.
Yes.
And get settled, because most of the efforts have already been made by the mediator.
Mm-hmm. No, in this case, it was a very precarious situation. The husband was harassing the wife like anything. About 7 or 8 cases were pending against the wife by the husband and all those things. But I feel myself to be at peace with what I did at that point of time.
My compliments to you.
Thank you, sir.
Sir, your video is still not, you are not visible, sir.
I'll make some more efforts.
He is visible to me.
Okay. Your thanks is visible, sir.
Okay.
So one more question, sir. Sir, regarding the nowadays there is a
just a moment, Mridul. First, let me deal with the situation.
Okay. So is it difficult, sir?
It is fine now. We can go ahead.
Yes, we can. Yes. Sir, can I ask a question?
Yeah, sure.
Yes, now you're visible, sir.
Yeah.
Now, nowadays there is a video coming on WhatsApp and everywhere. It's on the YouTube. One, like in your lecture, you have said that the judge should not mediate. But there are videos viral, and some judges, they are mediating and settling the matters. So, what do you have to say about it?
Mridul, thank you very much, because whenever I have seen these videos, and especially in past 2-3 months, and especially of the same judges.
Yes.
So I'm surprised how these videos are made or whatever. And Sivanathan, obviously your expressions are helping me and guiding me. Frankly speaking, the judges sitting on the dais and assuming them and appointing themselves to be the mediators. So Mridul is very right. And but the thing is that if we did not see these videos, we would not even come to know that what is happening.
Dear Mr. Ajay Mehta, I sent a message, direct message to you. Can you please see the chat? There was a mediation.
Yeah.
In that, the wife is a young advocate practicing here.
Yeah.
And they lived in US and they had some differences with the husband. She came back, bringing back her two twins. There was a mediation because of the litigation between husband and wife. And in the mediation center, the husband gave an undertaking. You please give the passports, US passports of the children who were born in US. And then after getting the visa, I will return back. Under the mediation agreement, wife said, agreed that, believing that it will be returned, she gave the passports. He went to the US embassy, got the US visa, and took away the children. As per the US law, you know that it is a parental kidnapping is an offense in US. But here, when the mediation agreement is violated, she reported to the court. court said the ball is in your court. What is the remedy for that?
It's it's a serious issue.
Yes.
But there are things, even though I think that I did speak candidly and perhaps exceeded the limits of a resource person or a speaker, but I will thank you very much for sharing this. But yes, mediators ought to be trained in a way about the worst things that can happen and how one party can take the other party for a ride and deprive so seriously, and leaving them with no remedy in law possible.
Yeah.
I fully appreciate that. Mridul, I think that something still remained, some part of your question.
Yes.
Please.
Yes.
The-
Sir, I would go to the another question, sir, because this is Advocate Mandeep. He is asking in the chat box, sir, what is the remedy available to the litigants if the mediator is biased towards one party?
Yeah, seek a reappointment of the mediator.
Okay.
Yeah.
Yes.
I'm
By the,
seeking the reappointment so that the in charge or whosoever is there can go into it. That's it.
okay. And one more question is there, sir. Is it ethical for mediator to take a matter if he knew one of the party earlier, or he should disclose it to both the parties and go ahead with the mediation?
You see, the normal belief and the answer historically, whatever I have been getting to understand from 2006 onwards, is that no, you must announce it to both and say this to both the parties. But actually, some iota of doubt will still be there. So it is better to avoid that.
But
Okay.
Mr. Ajay Mehta, I like to share one idea that in the US court, in one of the things related to this case, similar case was happening on Indian couple. They moved the court in the US, federal court, and they gave the permission of the passport and child for travel to India. But the husband took the child to London, and then he never came back to India, but he failed to inform the wife. So the wife informed the court what this happened. Then immediately the federal court withdrew the order and ordered the arrest of the husband. He was arrested in the London airport and he was repatriated to US. That has happened in US. I think when a mediation agreement is violated in a court-referred mediation, the court must have the rescue. Is it correct?
Well, I cannot make any comment on whether it is correct, but one thing I'm sure that I need to meet you, Sivanathan, because I think I will prefer to modify my presentation after enlightenment, because what you can further share if we meet, have a sub caucus, I can learn a lot from you. But there are situations which you have mentioned. This can be very serious.
Yeah.
If in the midst of a mediation, if we have to go and seek protection from the court, or we lose a valuable legal right, well, anyway, then what was the sense of direction of such a mediation?
In this case, the wife is a LLM graduate.
Imagine. So,
Pathetic.
Yes, sir.
Ask
Can I-
Jamshed Pey, can you please ask the question?
Yes, I'm ready with that. Mr. Mehta, you in one of your slides contained a Hindi quotation. For non-Hindi people, will you please be able to explain that?
which one was that?
किसी की मदद करते हुए उसकी तरफ
I
इस
will have to
तरह
do
मत
that.
देखिए
Yeah, Jamshed. Yes, I'll tell you.
कि उसको एहसान का एहसास हो.
Ji. Thank you so much. These are my favorite lines.
Yes.
Well, what happens as a mediator? I think you may be more aware about it than me. That what happens that most of the mediations are successful, and the parties become very emotional and notional. If they are young ones, They touch your feet. Good to see you, Jawad. Hi. Jawad, I'm talking to you. Yeah.
Yeah, Ajay Bhai, how are you?
I'm very fine.
Oh, sorry, I joined late. I just joined now.
You're most welcome.
Thank you so much.
Yeah.
Thank you. Thank you. Please go ahead. Thank you.
So they become emotional on the outcome of the mediation, successful mediation, because until it happens, the parties are not hopeful that is it really going to happen that way. So since a mediator and a mediation trainer very strongly believes in eye contact, Jawad, I talk a lot during mediation trainings about avoiding the eye contact when need be, because the thing is of our culture, the gender issues. So it's not necessary that we must continue with our eye contact, especially when the parties are expressing gratitude for a successful mediation. Then within me, I know that I cannot take a credit for this successful mediation. It is happening, maybe it is a divine intervention, or it is happening with the blessings of my gurus, whatever. So having a eye contact at that point of time with the parties, this may take away my ability to do better.
So this is Mr. Arun Sharma, advocate. I think he is asking a question. Is there any provision for mediation in criminal cases, sir?
But we are talking about ethics, so we cannot go to that. You may have speakers on to enlighten on them.
Sir, a very interesting question has come up here. Mr. N.K. Rajput is asking this question. His query is that when both the parties are very protective about their stories, they are not divulging anything. So can the mediator makes his own investigation in the matter? And if yes, what are the tools available to him?
Well, communication is one topic.
Yes.
Where I think that somebody who has not spoken for ages will also unwind. The question is of being provided the comfort zone. And there are tools and techniques. Why at all it is 40 hours training or even longer than, and sometimes even that is not enough, where we need experts like Jawad to help the mediators in understanding in a much bigger way. Because I think Jawad will agree that 40 hours training is a basic training. And this assumption comes not only in those who have taken 40 hours training, even in those who are on dais. Without any mediation training, they assume and they appoint themselves as the mediators. So the techniques have to be understood very deeply, all the nitty-gritty, and it has to be practiced a lot.
Yes, sir. Very true.
So
I hope Mr. N.K. Rajput.
I'm sorry to butt in, sir. Mr. Mehta, in fact, a little different what I was trying to place the question as about being vigilant. Okay, is when one of the parties, none of the parties, in fact, is spilling the beans. Okay, it's not trying to tell the right thing, but the mediator has this nagging doubt in his mind that something is actually not right here. Yeah. So my question is, can he certainly conduct his own investigation to find the real thing, what is happening between these two people or the two parties? That's my question.
My personal experience is that if there is something wrong, somebody is really hiding something working in the forefront or back of their minds, then I think that eventually the mediator develops this quality, getting to know that what is happening. Somebody is really playing a game, and if that be so, then the best technique that I believe in is to defer it. Now you defer it for half an hour, 2 hours, important. The truth comes out and you become clearer, sharper. It's only the understanding and diagnosing the situation When I'm talking
So,
about this,
Mr. Mehta, can I just add? Will
Yeah,
will a mediator become an investigator? Can he become an investigator?
no, never.
That seems to be what the gentleman really wants to know, is that he goes on to a
Within,
investigation spree.
within your mind,
Not exactly the investigation spree, but when
yeah.
there is a particular nagging doubt. So my question was, can he certainly try to find out? It is not
Still for
necessarily do.
Again, if he tries to find out, the parties have to consent to a settlement. If one party is trying to play truant, then it will be a sad situation. Every case is not meant for mediation.
Absolutely right, sir. So my
And
question
also
was
today-
based on
Very
that, whether they can do it or not.
And also today, Mr. Mehta has thrown light on something which is very essential, and we have learned a lot, and that is self-determination. We have now mediators crying from rooftops, I settled 30, I settled 40, I do this, I do that. Just like every case cannot be fit for mediation, every lawyer cannot, or every person cannot be a fit mediator. It's a very tough task he has explained to us today.
I respect that. It's very true.
Very true, sir. Very true. Absolutely right, sir.
Now, to become a good mediator, you have to delitigate your mind.
Very true.
Very true, sir. Very true.
Question, sir, can I ask? If a mediator is to be a facilitator, should they not be suggestive in the session, such as suggesting better solution than the ones that the parties bring to the table, or will that be unethical? Am I clear, sir?
Mridul, your voice was not very clear, but still whatever I've understood. Sometimes the speed of converting joint sessions and single sessions and replacing them, sometimes that's very important. So that takes you to the right way.
No, what the question is, sir, that maybe that they are not coming with the right solution. So can the mediator suggest a better solution?
No, mediator does not suggest. Let's be clear about that. But our questions and our sessions and the delicacy with which we handle the situation and try and understand and asking open and closed questions whenever, wherever they are required. What goes wrong, Mridul? That instead of when the mediator is supposed to indulge into open questions, he asks the closed ones or the hypothetical ones. So we need to inculcate a good culture, have a fair understanding of communication, and then rest all happens very smoothly. If something is lacking in our training and in our understanding, the skills of communication.
Jamshed ji, you have a second other question, more questions to ask?
Yes, I have got a question from Miss P.S. Chandralekha. I'm sorry if I'm pronouncing it wrong.
It's correct.
It is the question goes as this: in matrimonial matters, the mediators in due course of settlement cannot get into document on record before the court or lower court or family court to check veracity of facts averred. How to deal a situation where there is conflict of facts stated before court and mediator? Probably, sir, this is the reason why we are not supplied with court documents. We only get a letter of appointment as mediator.
So Jamshed, you are right that now we don't have the records and court file. Initially we used to.
Okay.
And that I'm talking about 2006.
Mm-hmm.
So 2005, 2006, up to 2008 also, the files were being forwarded in mediation, and they used to block and develop a bias.
Yes.
So first of all, we are lucky that that practice has been dispensed with.
At least we are free from bias.
we are free from bias from that point of view. Yes.
Mridulji, I think Dr. Bharti Rao has raised her hand. She wants to ask a question.
Okay.
I wanted to congratulate Nivaran for this excellent presentation. And Mr. Ajay Mehta, it's been wonderful listening to you. Thanks for this opportunity.
Thank you, Bharti.
Yeah.
Okay.
And especially coming from a lawyer, the legal fraternity, the nuances of language were very well explained by you. And all the examples are, very much, they're very nice from the perspective of a mediator. Congratulations, sir.
Thank you, Bharti. Will you allow me to go to Jamshed for a moment?
Yes,
Yeah.
yes, sir.
The
Please.
issue that I was touching earlier about the file and non-availability of file.
Yes.
So Jamshed, the one more beautiful aspect that I very strongly believe in, that is that one is that we are free from any bias or prejudice going through the file. But the second more beautiful thing is that when settlement is happening, or we are heading towards a settlement, mediated settlement, then the relief which has been prayed for in the pleadings on both sides, that does not chase us, because normally I will say,
Yes.
normally the outcome of a mediation may not be close or nearby the plea, the prayer clause, or the relief sought for.
Yes.
So
Sir.
we get the freedom
Mhm.
so that
Very true.
a settlement can be designed by the parties.
That is where the topic of self-determination comes in.
Topic of self-determination, that's absolutely fine.
Yes. Mridul?
Yes, sir. So there is one Mr. T.R. Arora. He is asking, can a guide or a book be recommended which details the do's and don'ts for the mediators?
Yeah. Well, I think that we must read the books and whatever. But Mridul, I will perhaps give me the liberty to go little deviate from the question. There is something which I would like to share with your audience.
Yes, yes. Please.
There is something which I'm going to share. Let's say, for example, a mediator, or even those who, more about mediation. There have been suggestions from me to the authorities that, first of all, I'll start with this. The first phase, that for a mediator who has become a mediator, he must maintain the copies of settlements which have happened in mediation. Because whatever, suppose if today also I go through the mediation settlement, which happened in 2006 or 2008 or whatever, today my outlook will be different. That this should have been more comprehensive. It should have been a bullet points, not paragraphs, and whatever. So it will encourage me today also, self-improvement. Besides that, the settlements, without divulging the names of the parties and details, there should be a system that to educate the new mediators, they should be circulated.
Yes, very true.
I think Mr.
So there is
Jawad.
not-
So yes,
Yeah.
sir. Please continue. I think Mr. Jawad has the question. Mr. Can you ask personally, or shall I read it?
Yeah, please read it.
Okay. Facts, truth, investigation, solutions. I hope these questions are coming from people who are not mediators. If the mediators are asking these questions, they need to introspect and rethink about their role as mediators. This is the observation I think Mr. Javed has given us.
He's Mr. Jawad.
Yes,
Jawad.
So that's very nice of him.
yes. Mr.
Can,
Jamshed, you have a
can,
question?
can some light be thrown on this observation by either Mr. Mehta or by Mr. Jawad? Because this is very crucial for us. The
Yeah,
mediators.
now some of the questions that were asked,
Hmm.
what I realize is these are basically questions that cannot come from mediators.
Yes.
Because mediators know that there is no such thing called the truth. It is only a perception of each of the parties. There's no such thing as an investigation because a mediator is not a fact finder or a judge who's going to find out what is the truth and perhaps pass some judgment or something else. So I think there is a need. If mediators are asking these questions, I'm really sorry to make this statement, but if mediators are asking these questions, I think they have to seriously think about whether they should, once again, relook at their roles and whether they should really understand what exactly is expected of them as mediators. So whether a solution is a right solution or a wrong solution, who is a mediator to decide that? I simply don't understand that question at all in the first place. Who's a mediator to decide whether the party is telling the truth or not telling the truth? So I think it needs a much, much deeper conversation. Sorry, I joined late. I don't know what Ajay Bhai has already, he would have explained, I'm sure, because he referred to self-determination.
Yes.
When you talk of self-determination, the question of mediators' solutions or mediators investigating or mediators knowing the truth doesn't arise at all. And one more question that was asked was parties' reluctance to speak.
Yes.
The only thing that the mediator can do is make the parties feel comfortable, assure them that he or she is a friend who's there to help them, and encourage them to speak. And if they still don't wish to speak, now we are talking mostly about court-annex mediations where parties' consent is not asked for before they are sent to mediation.
Hmm.
So that is where I think the mediator's opening statement plays a very significant role in helping the parties to understand what is it that they can expect in a mediation. But in most court-annex mediations, I'm very sorry to say that there is no opening statement from the mediator explaining what the mediator's role is, what the parties can expect in a mediation. Nothing is done. So therefore, the parties don't know. They don't know whether they can trust the mediator. They don't know about the confidentiality. They don't know that they can walk out of the process if they are not comfortable with it. So whose failing is that? If the party is not talking, whose failing is that? In my opinion, it's the mediator's failing. Because the mediator has not established the trust and rapport with the parties, has not made them feel comfortable enough to open up and speak about what their fears and concerns are, what their perceptions are. So let us not forget that mediator is only a facilitator of negotiation, a facilitator of communication between the parties. Nothing more, nothing less.
Mridul, any other question on ethics?
So Jamshed ji, you have some queries?
Not exactly on ethics. It is tangent to the ethical aspect of this thing. I've got a question here by Soham Shrit, Mr. Soham Shrit. I don't know whether I'm pronouncing it right or not. He says that according to you, in case of conflict between behavioral ethics of mediator and interest of parties, who/what should prevail and why?
The ethics.
Yes. Very short answer and very crisp answer for that is ethics.
Thank you, Jamshed.
Welcome, sir. Mridul, do you have any other questions? Mridul, do you have any questions now?
Jamshed, I do not know any probability of questions. All are welcome. But one thing is for sure.
Yes.
Maybe perhaps Mridul will terminate this session as per the timings. There are stipulated timings, I can understand. But
Yes, yes.
before that, I would like to express myself to the extent
Please,
that
please, sir.
and I think that you can trust me that we started around 5.
Yes.
And the clock is showing, indicating that perhaps any time Mridul can announce the closure. But
Yes,
I
yes.
have enjoyed this session so much. I feel delightful.
So nice of you, sir. We are all, it's
Because
our pleasure, sir.
please don't, I mean, it's not expressing any biases, but looking at Mr. Rajiv Datta, Sivanathan, and Jamshed, especially you, I think that, you know, it was like as if we have never met actually.
Yes, yes.
It's so. But I don't think that I will be, whenever I meet, I will feel that we are meeting for the first time. So thank you so much for this comfort zone.
I'm really thankful for that privilege, sir.
Yeah, I'm very happy.
Ajay, we have enjoyed the session thoroughly and a lot of learning, you know, because normally what we are doing in many sessions, we find the inputs are very, very technical. And when we actually sit down for mediation, we face very normal, basic, fundamental things which you explained today, which somehow, you know, to apply theory. See, when you sit down for a mediation, two parties in front of you, they bring their relatives, they bring, you know, a situation which we can envisage. But what is happening is at that time to start thinking, and this is the, you know, what you have also explained very well, although you did not put it in words, was, and I have gathered it, that experience of a mediator is what mediator, you know, the selection of the mediator should be based on his experience, how long he has spent, because this is not something we can overnight learn. And let me be very frank, I don't mean any disrespect, but when judges are appointing judges, retired judges as mediators, I would say there is an element of putting some kind of pressure on the parties. They understand the law, therefore they will be able to do this settlement. I'm very sorry.
Rajiv,
Jawad has explained it very well.
I felt touched on what you said before this. And since sometimes you will appreciate that there are linguistic barriers, I will use the word riyaz. Sangeet mein hum shabd istemal karte hain, riyaz.
Practice.
I wish that, you know, our mediators, they really start understanding this aspect.
Yes.
That not just the training or some awareness programs. Actually, what they need is a lot of riyaz.
Yeah, it's like music. Practice, practice, practice.
It is. So
Mridul, everything is left to you now.
You are muted, Mridul.
Mute, unmute.
Okay. So there is a last question, Jamshed ji. Can you please ask that question? It's in the chat box. Can you please ask that?
Please, the question says, so from Aparajitara Sharma, the question reads as under, if mediator should have creativity, then why she shall have to follow book or ethics? So it is creativity versus ethics.
no, it cannot be creativity versus ethics. Ethics is ethics.
Her question is like that.
Yeah, it is. It's very, they are justified in putting the question, but the answer is ethics, ethics, and only ethics.
My response to this would have been that you have to maintain ethics in any case, and creativity should fall within four walls of
Within the
ethics.
four walls.
Within four walls of ethics.
Yeah.
That's how I would have put it.
I'm thankful to you for the answer.
Very well put.
Yes. So now we are coming to the end of the session, sir. So I would like Mr. Jamshed to put a thanks note on the board.
Sir, this session has been a very educative one. We have come across so many new aspects in terms of ethics, and we have learned so many techniques and ideas and different dimensions of negotiations. Sir, you were very kind enough to introduce us with the right of self-determination concept, which I feel is the backbone of mediation process. Unless, because every time whenever we enter into a mediation, we always tell the parties that it is you who has to decide the things. It is you have a freedom to decide your case. You have authority to decide your case. We are there to support it. Things like that. To me, a process of mediation is dissolving the dissolving the invisible walls that people have or parties have. We call them unawares, have built around them. Unless that is dissolved, we cannot make any process or any progress in that. Sir, you have raised a point of, rather you have explained the point of impartiality. I'll just put it in my words, what I have understood it is that it would be wise not to take anything personally. If you leave personality out of it, you will be able to see opportunities more objectively. And second thing is that most difficult things in any negotiation almost is making sure that you strip it of the emotions and deal with the facts only. So these are the two things on which I work. And sir, with your lecture through this session, this belief has strengthened now that I'm going in right direction. So I'm really thankful to you for the valuable lecture and enlightening us on different aspects of ethics of mediation. I'm also thankful to thanks to our Nivaran team who has organized this thing, this session, and a special thanks to Rahul. Had he not been there, we would have not probably seen each other even digitally. So he is the backbone of our program, and Miss Mridul has been very eloquent in this entire session. Thanks to her, Mr. Rajiv Datta ji, JM Sharma Saab, Rakesh Khanna ji, and all the participants. I'm thankful to all of you. And with this, I'll call it a day. Thanks to you all for sitting through very patiently. Have a good day. Thank you.
Thank you very much.
Thank you so much, sir, for coming on the session, sir. Thank you.
My pleasure. And my best wishes to Nivaran.
Thanks a lot.
Thank you. Thank you very much, Mr. Mehta.
Thank you, Ajay. Thank you so much.